certainly an unusual case. I think that rather than prolonging this matter, Ms. Brinson should have looked to end it very quickly. And I believe that Ms. Brinson has done herself no favors with how she has chosen to handle this case, or with her responses to the ruling of this court. As a member of the bar, Ms. Brinson is held to a higher standard than a layperson. It is not sufficient to come before court and say, I have not done post-judgment discovery. A lawyer in this situation has a duty to inquire and a duty to find out what is expected. It is also not sufficient, and I have reviewed the discovery responses one more time and do find them wholly lacking and non-responsive, not to mention unverified. It's not sufficient to file discovery, especially when you're at the point where there's a motion to compel that's been filed and an order that has been entered in such a manner. I must admit being somewhat puzzled by Ms. Brinson's handling of this case. Even as of the start of the hearing today, there was no sworn response from Ms. Brinson to the discovery that's lawful, that has been propounded. I didn't think there was anything unreasonable with any of it, especially considering that it's post-judgment. It was only in response to my close questioning of Ms. Brinson that she even swore to it here on this witness stand today, that her responses, such as they are accurate. I'm struck by the fact that even for records for which Ms. Brinson plainly has access, such as tax records, deeds, matters of public record, she has not produced them. I am also struck by the fact that at no time today, given the procedural posture of this case, has Ms. Brinson even offered a date certain for compliance. And all of this points to the following findings of fact. Ms. Brinson knew that she was to comply. She was fully apprised of her duties under the discovery statutes of the state, as evidenced by her own reference to the Civil Practice Act. She was also fully aware of her duty of candor to this court, fully apprised of her other responsibilities under the rules of professional conduct mandated by the State Bar of Georgia, as evidenced by her references that were voluntary, unelicited to certain matters that she has that involve the State Bar. I find that she has knowingly and voluntarily failed to abide by the order granting defendant's motion to compel discovery. I find that this is her willful, free, and voluntary effort, that it is part of a pattern of a prolonged effort to expand these proceedings, casting the blame on every person other than herself. I'm going to order that Ms. Brinson be confined in the common jail of this county by the sheriff until such time as she shall choose to purge herself from such contempt by truthfully, accurately, and completely answering under oath with a verification defendant's first interrogatories, the plaintiff in 5A, and defendant's post-judgment request for production of documents. As for attorney's fees, I will rule as follows. I find that the hourly rate that has been testified to by Mr. Alderman is reasonable. I find that given Ms. Brinson's own testimony that it appears to fall within the standard of what is charged in this community. I further find that this is not an unduly or overly complicated area of the law. Civil contempts are handled every day, and given the level of complexity, what I have heard concerning the fee structure in this community and the fees charged by this lawyer, I do think that these are reasonable. I think that the overall amount of the fee testified to is reasonable, so I'm going to assess fees in the amount of $6,922.50. That would be payable 120 days from Ms. Brinson's release from confinement.